All right, Tyler Ashbaugh,
Judge.
good morning. All right, today is the plea deadline date?
Yes, Judge.
Yes.
I've actually filed a motion for inspection of physical evidence. I know it's the plea deadline. We're not inclined to accept the offer at this time, but I do have some ongoing discovery matters that I'd like to bring to the court's attention.
All right, what ongoing discovery matters?
So I have a motion for inspection of physical evidence. Number one, and the state does not have any objection to this. I would like for our investigator and expert to have access to the white Nissan Rogue that was seized in this vehicle
Mhm.
for the purpose of downloading the event data recorder data from that night. I believe it's going to be material and possibly useful in our defense, Judge. And then also just to inspect all of the physical evidence that was seized or documented by the police from that night. I believe the state will probably be offering most, if not all of that evidence into a possible trial. And some of it was a little unclear when I'm going through the reports to see, is this a casing? Is this a bullet that's marked? And I don't want to take any chances. I want to know exactly what each documented piece of data is and lay eyes on that. As I said, Judge, the state doesn't have any objection, but would like to be present, which I understand. So I think that we're going to coordinate a date where myself, the prosecutor, and this detective on the case can all be present and knock out these things. I know that the state says that they have a murder trial next week, but they're going to try to reach out to the detective and schedule a mutually agreeable date for all of us to be present. So we would ask for a 45-day reset just to take care of these matters, Judge.
All right, so I see that you were substituted in April,
Yes,
because otherwise I was going to ask you, why are we just discovering this now? But I see you were recently substituted in.
that's correct, Judge. And there's a lot of discovery on this case, and I've been trying to go through it diligently, but there's just a ton of information.
All right, so when is this going to happen? The inspection of physical evidence and the download of the device?
So Judge, I plan on reaching out to the detective today, trying to hear back. I don't know when the detective's duty days are. Once we hear a time frame, I think defense and I are gonna throw out dates just so that we can give options to the detective. You know, we can schedule time for all of us to go and do this, and try and knock it out in one day.
All right, so here's the thing. I'm going to give you all a reset till July 29th. Everybody needs to have done whatever they needed to do. All right?
Understood, Judge. Thank you.
Yes.
Wait, hold. Oh, okay. My client was just saying that July 29th is his wife's due date. If we could do maybe the week before.
Does
Is
she
that
really
okay?
want you there? Are you going to pass out? Are you going to be helpful?
Yes, I will be helpful.
I don't know. I've seen plenty of
She asked me
videos.
she asked me the same
Yeah.
question, but
I've seen plenty of videos where people just pass out. They're not helpful. All right. July 22nd, is that enough time for everybody?
That should work, Judge. If there's some issue with the detective, if, you know, if they're out on vacation or leave or something else that's preventing us from going by that date, we'll let the board know.
Okay. Well, congratulations on the soon-to-be new baby. Babies have their own schedule,
they do.
so realize that you work for the baby.
Maybe
Once
make
the
out a
baby is
week early
born.
and be on that day too.
Yeah.
I was thinking.
Yeah.
All right, so we'll be back on July 22nd for the discovery issues. And do you have the motion?
I do, Judge, here. And there's the order's the last page.
All right, thank you. All right, they'll give you a copy of that,
Thank
the
you.
order,
May my client be excused?
once he signs the reset form.
Okay.
Sure.
It was filed yesterday, but I don't know that it's, okay. I don't know that it's been accepted yet. I haven't checked this morning. Okay. Okay. Okay.
Jacob Moya.
Is it? All right.
All right, so it's my understanding on this case, the defendant had entered a plea, is that correct?
Correct. Your Honor.
And did you plead no contest? The reason why I
I'm not
say
sure
that,
There was no contest or guilty, Your Honor.
it was no contest? Okay, because it's not written. Just one moment. All right, let me. Just one moment, let me review the stipulations. Oh, okay. Court is calling 2024 CR 0363, State of Texas versus Jacob Paul Moya. Can I have parties announced for the record for the state? Defense.
Jonathan Ross for defense, Your Honor.
And are you Jacob Paul Moya?
Yes, Your Honor.
All right, you entered a plea on April 25th of no contest. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 months in the state jail facility. There is no application for community supervision, and the state is taking in consideration 2024 CR 3404 as your plea bargaining agreement. The court has had a chance to review the stipulations. The previous judge found that there was sufficient evidence to find you guilty. The court is finding that there is sufficient evidence to find you guilty as well, and the court will find you guilty. Have both parties had a chance to review the PSI report? State?
No, Your Honor, but.
Any objections to the PSI report?
No, Your Honor.
All right, do you have any witnesses?
We don't, Your Honor, just arguing.
All right, I'll hear argument from the defense, and while the state is reviewing the PSI report, I'll hear argument from them after the fact.
Yes, ma'am. All right. So, Mr. Moya has been pretty open and direct in his narrative of the incident. Pretty open about and I think pretty honest about his personal difficulties and issues with drugs and alcohol. He didn't emphasize them a lot, but I do believe that he understands them to be serious.
So
And
translate for me, how does I have problems with drug and alcohol translate him to having been to prison before for robbery and having all of these cases, and according to what I read in the stipulations, stealing people's packages from mailboxes when people are waiting for their items and then they don't receive them because somebody has stolen them from mailboxes. I don't understand why the federal government is not involved because it's the theft of US.
no, he's accepted guilt of that. We have no justification for that, obviously, Your Honor. I was, the main 2 points that I would like to hit are that Mr. Moya, he's been in custody for about for 236 days now on this. He has been diligent in jail. He's not gotten into trouble in jail. He has been attending AA twice a week since February. Seems,
So I'm assuming you're gonna ask for something less than 12 months in the state jail facility.
respectfully, Your Honor, yes.
All right, so why should I give him something, and maybe he knows, why should I give him something less than 12 months in the state jail facility? He's already been, if this is correct, he's been to prison before for robbery. And what I'm looking at in the PSI report, he has a theft case. He got deferred for it. Criminal trespass, burglary of a vehicle, failure to identify, another theft case that was dismissed. I'm not going to consider that because it was dismissed. A burglary of a vehicle, second. Failure to identify that was taken in consideration. Failure to identify that was dismissed. Failure to identify that was dismissed. Assault, bodily injury, married, dismissed, missing witness. Possession, penalty group 3, less than 28 grams, dismissed because there was no toxicology report. Evading arrest, detention, dismissed, placed on some other form of probation. Theft of $100, enhanced jail time. Burglary of a building, rejected, further investigation. Possession less than a gram, sentenced to 5 months. Another possession less than a gram, placed on probation, revoked. A theft case, sentenced to jail. Fraudulent possession of identifying items, probation terminated. Robbery, sentenced to 2 years in the prison. Another fraud case that was dismissed, convicted of other. And burglary of a vehicle with 2 convictions, sentenced to 6 months in the state jail. Then you have this case. So why should I consider giving him less than the 12? You want to raise your right hand?
Yes,
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Jacob Moya, Jacob Paul Moya.
All right, what would you like to say?
Your Honor, I understand the severity of my charges. I understand my history, and I'm not trying to justify anything that I've done, but I mean, I have learned how severe this can get that I don't want to go away. I mean, this time it's just 12 months, I know, but next time it could be longer, and I'm not trying to see the next time. I'm not trying to do this. I see how this is. I'm not trying to do this. I can honestly say, I know I caught the charges just recently, but I do now think a little clearer, and I don't think how I was when I picked up the robbery or those other charges. I'm not that same person, and I don't want to be that person. I'm trying hard to push away from being that person.
I don't know why it's so hard not to steal.
Honestly, Your Honor, it's there. I think it's just easier to do it. I know people work hard for what they got.
I don't know why people don't want to work anymore.
No, I was working, Your Honor. It was actually that week. I wasn't working. I wasn't home. But
So other people who were at work, because see, I want you to internalize what you did. Other people who were at work waiting for their packages to be delivered. Maybe it's somebody's birthday gift. Maybe it's something somebody's mom sent to them. Maybe it's something a family member sent to them that can't be replaced. And there's somebody just waiting for the postman to drop items in the mailbox so they can steal it. taking somebody's vehicle, breaking into a vehicle, stealing items. That's some item that somebody worked hard for. I always would tell, I've been a defense attorney. I would have clients. They'd say, I don't have a job. I'm like, yeah, you do. They're like, what's my job? I'm like, you break into people's homes, you break into people's cars. That's your employment. While people are at work, you break into their house. Because I would always give my clients home truths to tell them, you need to look at what you're doing to society. You're a person in society that people have issues with because they're out here working hard, following the rules, and you're breaking them and breaking it in somebody's mailbox. I still don't know why the federal government doesn't start arresting people, because interference with the postal service, stealing mail, that's a federal offense. If you read the letters, even when a letter comes to your house and it's supposed to be in somebody else's mail, but the postman put it in your mailbox by mistake, you know what it says on there? It has a law on there about if you open this and it is not for you and you take it and you don't just put it back in the box, return to sender. Me personally, I always just drive around the corner, knock on my neighbor's door. Hey, they put this in my box by mistake. If it's junk mail, I just put it back in the mailbox because nobody wants junk mail really. But that's what you've been out here doing. And now you come to the court, you want sympathy saying you've learned. And I'm sure, hopefully, when you went to prison for robbery, did you learn anything from that experience?
Honestly, Your Honor, I'm not trying to justify, like I said, but when I went to prison, I was put in some difficult positions where I can honestly say, like, I pray that a lot of people that are about to go to prison, probably younger than me, don't experience or seen the stuff that I saw.
Now, here's the thing. I know horrible things happen in prison. It would be nice if people could be left alone, just do their time in prison and learn. But prison, really, the only way to be rehabilitated I see in prison, if you're like 100% about rehabilitation. I know people in prison, guess what? They get beat up. People in prison get their commissary taken from them. People in prison get raped. People in prison will rape people in prison. Then they get out and they go back to their wives, their family member, acting like nothing ever happened. Oh yeah, I just raped him because guess what? We're in prison. This is what we do. I understand prison is a horrible place to be. Bear County Jail is a horrible place to be. I had clients who were over there who were bit by spiders. Next thing you know, they have a hole in their leg. It happens. It's a shame it happens. There's nothing I could do about that. If there is something I could do about it, I would be right in there doing something about it. So I understand prison is not a fun place. And honestly, it's not supposed to be a fun place. Some people say, when I'm released from prison, guess what? I have to watch my back 24/7 because I'm used to in prison watching my back 24/7 because you never know who's coming after you or what they're going to do. I understand. But you get out of prison, which you say was a difficult time for you, and then you come out and you still do this.
Well, Your Honor,
If
Oh,
if I could just interject on my bad.
yes.
I do understand. I wasn't on drugs when I had committed the offense, although I'm not trying to justify it. Since I've been in Bear County, I'd like to point out, I spoke with my lawyer. He said it would be a good idea. I was a painter from January, February, and I just recently stopped doing that. It was for a corporal, and then her husband, which is a sergeant for jail programs, hired me to do mattresses, and they actually said that since I've been doing such a good job, they want to move me to the main jail to show the people, the other inmates, how to do it, because they're already going to be done with it there. They're starting like an initiative to I guess eliminate the damage of beds, to make them and clean them. And I mean, I like that, me doing that, working. That's honestly, I've lined up a job for when I get out. I'm really pushing forward to sticking to that plan, because honestly, I like the energy and just how I am, how I am as a person when I'm working and I'm doing something productive.
Okay. Anything else?
No.
All right. I want to let you know, I internalized everything what you said, and I understand that you're on a path. You're trying to do better with your life. But sometimes sentencing is about punishment. And so I'm going to give you the 12 months. I'll give you credit for any time served. I'm going to take in consideration 2024 CR 3404. Did you review the trial court certification with your attorney? Did you sign it?
Oh, okay, yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing, when you're released from the state jail facility, if you think you want to use drugs, if you're trying to find a place to stay, if you're trying to find a free place for rehab and you can't find it, if I'm still here, you can come back here. I will pick up the phone, call somebody with resources so that you cannot come back here again for this type of situation. Do you understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you for that.
Thank you, Your Honor.
Option, Your Honor.
You're welcome. Dylan Bell,
Yes, Your Honor, present.
all right, this is sentencing.
Yes, that's correct, Judge.
All right, and state on this one, the court had a question, or the court wanted the criminal history and whether there was any gang affiliation.
Also, Your Honor, as a housekeeping matter, I was appointed less than 10 days, so I don't know if on the record we need to address that before we begin.
Oh, no, we did address it on the, because he wanted to go forward with sentencing. I said, please don't do this because,
I remember, yes.
yes, but we'll put it on the record as well. Well, before we go on the record, Mr. Bell, would you like to give your attorney more time to prepare a mitigation packet for you? All right, have you had a chance to discuss with him about mitigation?
I have, Your Honor, yes. We've discussed that at length ever since being appointed on the case.
All right, the court is calling 2024 CR 3093, State of Texas versus Dylan Christopher Bell. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense,
Renee Munoz.
are you Mr. Bell?
Yes, ma'am.
All right, and Mr. Munoz, you were appointed to represent him. I know from our last time we were here, the court sort of insisted that he give you more time to perhaps present mitigation evidence for him
Yes.
and at least give you 10 days. I know he was balking a little bit at that, but ultimately he decided to give you more time. Is there something you would like to place on the record?
Yes, Judge, just briefly, I did speak with my client about the 10-day notice requirement for substitute counsel on a matter that's being set, especially something like sentencing. Did stress the importance of allowing me time. We have met on that date as well as today, and I have been working on his case aside from that. So speak with my client about those preparations made. I believe he's comfortable to proceed at this time, Judge. He's been in custody for the last 177 days pending this charge. So I think that's his wanting to get the sentence done over and done with, Judge. But we're respectful of the court's consideration, allowing us time that we need.
All right, thank you. And counsel, were you able to review the criminal history?
Yes, I was, Judge.
All right, state. All right, according to the plea that you entered into on May 9th, you entered a plea of no contest. The court found that there was sufficient evidence to find you guilty. However, the court deferred finding of guilt as you had applied for deferred adjudication and for community supervision. According to the plea, punishment is to be assessed at 6 years in the prison. The state is opposed to your application, and this will run concurrent with County Court Cause number 727864. All right, state, you're opposed?
Yes,
State, you may present.
we don't have any witnesses, Your Honor, but argument.
All right, defense, do you have any witnesses?
No witnesses, Your Honor, only argument as well.
All right, state, I'll hear your argument.
Yes, Your Honor, just due to the fact that this is a burglary of a habitation, this person actually was inside the home when it was burglarized. The reason that we have a reduced sentence here, the state believed that they took into consideration of the fact that the individual left after he was yelled at by the homeowner, but also tried to take the car, and that's where the restitution of $248 comes from, Judge. So that's why the state is opposed.
All right, defense.
Yes, Your Honor. My client is 21 years old. He's had no previous felony convictions. In fact, he was placed on deferred adjudication on the misdemeanor case. My estimation is they're wanting him to pay restitution on it, learn from it, grow from it, Judge. And speaking with my client, I spoke to him about his upbringing because the juvenile offenses did want me to.
All right, everyone, please make sure you whisper.
The juvenile offenses did want me to delve in deeper as to his home life was like back then. He stated that he did not ever have contact with his father whatsoever. He had two brothers and a sister, and his mom was raising them all. Admittedly, she worked full time to support and raise them, so he didn't have a lot of parental supervision growing up. Essentially, he would go to school, go home, hang out with his friends, do drugs, skateboard, do things of that nature. He started off using marijuana and cocaine at the age of 15 with some peers that he was hanging around with. And that usage has progressively gotten worse and worse over time. He's admitted to me, and he's being honest and truthful with the court, doesn't want to shun that. He had been using methamphetamine quite often. At the day in question of this offense, he was high on methamphetamine. He stated that he wanted to get the car just to go somewhere and drive so he didn't have to walk. He didn't want to resell it, didn't want to do anything with that. So just the nature of that has me going to the fact that I don't know what he was going through his mind at this time, but obviously it wasn't rational thought. He was in the house. He admittedly saw through someone there, wanted to get out, try to get the keys, try to take off in the car. But none of that was done. Nothing violent was done. It was not assaults. It was not him wanting to prey on another person. It was just him, I believe, being high on methamphetamine, and there's a causal link between the offense and those dependency issues, Judge. He's 21 years old, still going through some immature thoughts and facts. He's been in custody ever since this offense took place on December, Judge. So he's been in the Bexar County Jail 177 days. He's had a lot of time to think about his life. He's never been confined like that, and he has never been to prison before. I think that was a good shock to his senses that he was in custody for that long. He stated that he wants help with methamphetamine usage to get a handle on that, on those issues that we believe are causing him to appear in the criminal justice system, Judge. It was placed on deferred adjudication, county court number 8, cause number 723371. He was granted 6 months deferred on that case, Judge. Being that the DAs offered him deferred adjudication and didn't merely time serve him, I think goes to an indication that they want to work with him on a community supervision basis. I do know that the listed offense is serious, being in someone else's home, and I did stress that with my client. He stated that, you know, if he had the opportunity to get help in the future, he can see clearly, he can be a contributing member of society and not a detriment to society where they're having to pay for his stay at TDC, but instead allow him to grow and address the root causes of his issues, Judge. So this is why we're respectfully asking for the chance of community supervision. He's been in custody for the last 6 months. He's 21 years old, never been previously convicted of a felony, Judge. So I don't think it's too late to help this young gentleman to change it, hopefully change his life around.
All right, so here's my question. He's had violent offenses in the past, is that correct?
I believe just one assault family member.
He was an assault that's not associated with this case, and he also has an assault public servant that I believe was dismissed.
That was dismissed, Judge. That's correct. I believe the juvenile offense was when he was when the misdemeanor assault was when he was a juvenile, Judge, and he was on juvenile probation for that. I just think that the lack of supervision at a young age, not having his father and having his mom just work a full-time job and then have the 3 kids that he wasn't supervised. He thought he could do whatever he wants. No, there's society, there's rules, there's laws. And, you know, he fell in with the bad crowd, starting using drugs progressively, cocaine when he was 15. He's never had the chance for drug treatments. So we're just asking for a chance at some treatment, Judge. We don't believe he's going to get the sufficient drug treatment at the Texas Department of Corrections.
Oh, they have the therapeutic community, but
I just need for the juvenile adult public servant, he was on a top of probation.
all right. Anything you wish to say? You want to raise your right hand? You solemnly swear and affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Dylan Christian Bell.
All right, you need to keep your voice up so the court reporter can hear.
Your Honor, I've been thinking about everything I did through the stay in jail, And I just haven't had the chance to go through treatment. And I believe that this offense that I committed was because of me being on drugs, and I wasn't in the right state of mind. And I've been thinking about it long and hard for the last 6 months that I've been incarcerated. And I just don't believe that prison is gonna be the thing that helps me.
Oh, a lot of people, I can tell you this, everybody over in the box, they don't think prison is going to help them. I don't know anybody
Yes, ma'am.
who goes to prison who thinks it's going to help them. Even people who are charged with murder and are found guilty of murder. You know, at some point you could get probation for murder. And I know some people who have been convicted of murder, and you know what they say, prison is really not the place for me. It's really not going to help me. I need to be on the outside.
And Judge, I think that also something he's alluding to, that if convicted and put into prison, he would be a convicted felon at his young age and trying to get a job and trying to do anything in housing. He's just going to be pretty much kept down in society. Whereas if given, say, a deferred, it's not a final conviction, he can work his way off to that, pay restitution, make things right, do community service, get back to the community. And that would be a good test of him. I've already explained to him that if he doesn't fulfill the terms of deferred, that she can send you to the full range of punishments and indiscriminately send you to TDC, but he's asking for an opportunity to make it right, make the community better, and also make himself better, to not just be a detriment where he's cycling in and out of the criminal justice system because he's had a conviction, he can't get a job. So we're asking for just at least the slightest hope to keep his record somewhat clean, and have him work his way off this deferred over the years for hopeful dismissal.
All right, any questions, State? I have a question. Why are you in red?
I'm in red because I'm in segregation.
Why are you in segregation?
In segregation, because I got into the fight and they punished me. More so I had gotten assaulted, but they had punished me and put me into segregation for 15 days.
Last time, Judge, he had the bruise under his eye. Remember?
Oh, yeah, I remember that. All right, so if the deputies were to let me know why you're in segregation, would what you're telling me
Yes, ma'am.
comport to their system?
Yes, ma'am.
If,
Yeah.
if Tyler, the Odyssey system will let us see that?
That would be nice, yes.
All right,
Be nice.
Deputy Laura?
Is this for, he's in red for disciplinary?
Reference to that probably, but let's just know.
I don't know if that's the case or not. All right, just have a seat. I need to think about this for a moment.
Yes, ma'am.
Yes, Your Honor. Thank you.
Michael Shoemaker? All right, are you all ready to proceed on the motion?
Yes, ma'am.
Yes, Your Honor.
All right, court is calling 2019 CR 11017W, State of Texas versus Michael Paul Shoemaker. Can I have parties announced for the record for the state
Daniel S. Clark with State of Texas.
defense?
Sean Henderson for the defense.
And are you Mr. Shoemaker?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and cause number 2019 CR 11017W with your attorney, and did you understand it?
Yes, ma'am.
And are you the same Michael Paul Shoemaker who was placed on deferred adjudication in 2019 CR 11017W for the offense of possession of a controlled substance penalty group 1, less than a gram, in a drug-free zone? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7 on or about the 23rd day of May 2024 at the Port of Galveston, Texas. The defendant, Michael Paul Shoemaker, part of Bear County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True. Your Honor, state waives all the violations.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes, ma'am.
Court will find violation of condition number 7 true. Is there a proposed agreement?
Yes, Your Honor, it's to alter amend for MRT within 10 days and GPS for 90 days.
All right. Defense, is that the proposed agreement?
It is, Your Honor, and I do want to let the court know, my client lives in St. Hedwig here in Bear County. He works as a heavy equipment operator in Bernie and Kendall County here.
All right, so why is he leaving Bear County without permission?
Judge, he was actually going on a cruise, and that was the reason he left Bear County.
Was that cruise approved by the court?
It was not, Judge.
So is there anything you wish to say?
No, Your Honor.
It would probably be in your best interest, but okay. Probation, what are you recommending?
Patients recommending the MRC program.
All right, and so this number one that's in the motion, I'm not going to consider it as true, but what is happening to the new number one?
Judge, my understanding is that that was out of Galveston. That's ours. I didn't see
Okay.
anything pop up.
And that is correct, Your Honor. The new case is out of Galveston County.
So what is happening with that case?
It's currently pending, Judge. I don't represent him on that, and so I don't know what ultimately is going to happen with that case, Your Honor.
I'm not going to take that in consideration and not consider it. I'm sorry, I'm not going to consider it or take it in consideration since the state waived it, but allegedly,
Are you asking what the new number one is, Judge?
yes, who is
or-
the violation of the protective order with? Did he go on a cruise with the person he's not supposed to be with, allegedly?
Allegedly, yes, Your Honor.
So where do we, off the record, where does it come in that he violated a protective order? How did that happen? That people go on a cruise and things didn't end well?
I'm sorry, Your Honor.
Did he go on the cruise? Because you're saying allegedly he went on a cruise that he had a protective order against. He went with that person on a cruise.
He did, Your Honor. And so when he got on the cruise, since the cruise was leaving the country, Judge, I believe they go through and check everybody's passports. And it was during that process that they found there was a violation or that there was a protective order in place with the person that he was going on the cruise with.
Oh, and he didn't get to go on the cruise? They
He
stopped
did
him?
not, he did not. It was right after boarding, Judge, that that he was removed from the cruise.
Did he pay for the cruise of the person who he has a protective order against?
Yes, Judge.
He paid for it, or the person who he has a protective order against paid for it?
Both.
Both of y'all paid for it. Did they give you a refund?
No, ma'am.
Okay, this is just questions that I have. I'm always curious about things. All right. We can go back on the record. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Paul Shoemaker.
All right, why do you have the tape around your wrist? What's going on?
So and when you get booked in the main jail, it's every stage you go through. And
Ah,
I just didn't take it off. They took me straight over this morning, so.
okay. All right, this is probation's recommendation and the state's recommendation. What I'm going to do is deny the motion. Is this his first motion to revoke?
I believe it's the second, Judge.
I'm going to deny the motion, alternate amend conditions to ISF cognitive. And with regards to his transfer, does he need his probation transferred?
No, he's living here in Bear County, Judge, so he doesn't need probation transfer.
All right, he's going to remain in custody until transferred. And has he done anything on probation? Has he completed the parenting classes?
Yes, he has, Judge.
Yes, ma'am.
All right. All right, is there anything else?
No, Judge, not at this time.
All right, upon release, you need to immediately report to probation. Do you understand?
Yes, ma'am.
And you are not allowed to leave Bear County without the court's permission. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you, Judge.
Just have to leave the-
Daryl Fields.
Morning, Your Honor.
Good morning. All right, you're here on a bond reduction, is that correct?
Yes, Judge.
All right, the court is calling NIMAG number 752304, State of Texas versus Darrell Anthony Fields. Can I have parties announced for the record for the state?
Let's call it the state of Texas.
For the
Ray
defense?
Lopez for the defense.
All right, and are you Mr. Fields?
Yes, ma'am.
All right, is there a reason for the delay? Is he okay?
Yes, I do also have mental disabilities. That's partially why delay. So
Okay.
bear with me.
No, I just always want to know what's going on. That's why I asked.
Thank you.
Okay. All right, we're here on a motion to reduce bond. State, have you had a chance to review the motion?
Yes, Your Honor.
All right, is there a proposed agreement?
No, Your Honor, I hear this on the.
Ah.
This morning, there was no drug class.
All right, so what is going to happen with this case?
Judge will be sitting out there until we get drug labs back. We hear back whether or not we're gonna get tested. My understanding is that it got sent out, but so far nothing's come back.
And when was it sent out?
Close to the offense stage.
Okay. All right, what is the defendant's criminal history?
As far as I can tell in JD, there wasn't much of that. The only other thing I see pending, Judge, is an outlaw for the vehicle case.
All right. And if you want to place on the record, counsel?
Sure, Your Honor. Judge, we're here on that writ for habeas corpus. My client was arrested and incarcerated for this offense back on February 21st, 2024. Since that time, we're here on June 5th, 2020.
June 6th.
2024. And since that time, there has been no indictment, and we have looked through the records, myself as well as the assistant DA, and found no PR bonds have been granted. So we'd ask that the court release him on his own personal recognizance. As he's not been indicted in the state, he's not ready for trial.
Where would he be staying?
I'm not sure.
Do you have a place to live?
Yes, ma'am.
Who would you be staying with?
I will be staying with a very close church elderly person that is on the west side.
Okay.
And yes, I do have transportation to get to court.
Well, let me ask you this. The person that you're going to be staying with, have you asked them if you can live with them?
I have been living with him off and on. And he did have some medical complications while I was in jail.
Mhm.
So so that's where I stand on that. I do have, I did get approved for lifetime and for lifetime recovery, and is willing to do that, go there for a place and do that.
All right, so then this is what I'm going to do. Because I want you to be in a stable place. I'm going to grant a PR bond. I'll have the fees waived. I'm going to ask for a referral to Center for Healthcare Service or some sort of mental health treatment. And he's going to be transported to lifetime recovery. And we'll do drug testing. and I'll ask that the fees are waived.
Thank you. May I ask
Yes,
a question?
yes.
Um, with that,
Okay, I'll go through each one of them. So a PR bond, this is what that means. I'm going to waive the fees of that. So that means that you're not going to be required to come up with money in order to be released from custody. The reason why that's being done is because legally, because nothing has happened with your case in 90 days, legally, I have to give you a bond
Right.
that you can make. And so based upon what your attorney has said and based upon what you said to me, the only bond that you can make is a PR bond, which means you don't pay anything because I'm saying that the fees are waived. I'm going to ask that you be referred to Center for Healthcare Service or either to some place for mental health treatment because you've expressed to me that there are some mental health issues.
correct.
Then, so you'll have a place to stay. You've informed me that Lifetime Recovery is willing to let you stay there. So I'm going to ask that you be transported or Lifetime Recovery will come and pick you up from the jail. And that's where you'll be staying at Lifetime Recovery. And then I'm ordering that you be tested for drugs. Lifetime Recovery will do that, but I'm putting that in the order. And normally you will have to pay for that, but I'm asking them that they not charge you for that.
Okay.
All right. Is there anything else you don't understand?
No, I think you answered all my questions correctly.
All right. You're welcome. Make sure you're not allowed to live with that person you were previously living with. You're going to be at Lifetime Recovery. If there is a problem with Lifetime Recovery, just come back to the court before you decide to move or do anything of that nature. All right.
All right. And I know Lifetime is a 45 to 90-day program.
Mhm.
Will they help me transition after the 45 to 90 days?
Yes.
Okay, thank
All right.
you.
And Ms. Ferguson, on this case, even though it's pre-indictment, can you give them maybe a 65-day reset just so we can keep tabs on him to make sure that everything is going well? All right. All right.
August 8th or the 15th.
Council, August 8th or August 15th?
Check on my calendar.
You're welcome. Thank you.
Yeah, August 8th is fine.
All right. Krinky Van Fume. Is the attorney here for him? Who is the attorney?
They're calling you.
Come forward.
Good morning, Judge.
Good morning. All right. Have you conferred with the state?
I have, Judge. State has made an offer that would include the misdemeanor, which is set next week. So we're gonna go ahead and take care of that downstairs next week on his misdemeanor day, Judge.
All right. State.
Yes, Judge, we made an offer on both cases, but it took off for them to go take an offer.
All right. So when is that? What date?
I believe it's June 12th, if I remember correctly, Judge.
I didn't look at the decision date on this, but I know it was the.
All right. Can someone look up for me and tell me when the misdemeanor case is set on Krinky? How do you pronounce your name?
K.
Krinky and the last name?
Van Fumi.
Van Fumi. Okay, at least I had that part right.
I have it in my calendar.
Oh,
June
yes,
12th,
it's
Judge.
June 12th. All right, so what we'll do is we'll reset this for June 12th. I'll make a notation in my on the docket sheet that you're to go to misdemeanor court first, and then you'll come here. All right, Ms. Ferguson, on this case, they're coming back on June 12th, but he's going to go to misdemeanor court first. Once you have the reset form, your excuse.
Thank you, Judge.
Thank you.
Have a good morning.
You too. June 12th. Ruben Torres. Yes.
We're gonna need an interpreter, and I did not tell your coordinator, clearly.
All right. Is your client a citizen?
Yeah. He is not.
All right, we will find out. Oh, okay, we'll just have a seat. And did you let them know now?
I did, Your Honor. I apologize.
All right, thank you.
1, 2 days.
Are you all ready on Elisa Hernandez?
Yes.
Okay. Thank you for your patience, Mr. Piker.
I see you for busy.
Well, you know, the way Tyler has done the system, it's just going to take some getting used to.
It's no better in the private sector.
Oh.
We have clients that I know that I have cases on that have no file is found. So they'll be glad to hear that.
Out of it today.
All right, who's the prosecutor you're working with? All right, so this is the third violation report, and they're saying that your client does not report.
Yes.
So what's going on?
Well, fortunately, we do have a pretty good update. She was in jail up until May 16th. She suffers from major depression. She was not on her medication. She was living under a bridge. She didn't have her phone. It was stolen, broken. I don't know, but it's gone.
Mhm.
On May 16th, when she got out, she was picked up by her brother, Julio Hernandez, which I will call up here for you to talk with.
Okay.
He has taken her in. She lives with him. She's back in the stream of things. She was with probation on Friday, for her recollection. She got a new probation officer, Freddie Williams, has his phone number. And right after she got out, she also went back to her doctor. She calls her Dr. Yolanda at the Kellum office on Marbach, who put her back on her Zyprexa.
Mhm.
So she's back on medication. She did come to court. She's come to court every time that, except for when she missed the lift. But last week she was here and she was insistent that she had court. I was the one that told her, I can't see where you have court. It's the 25th, and told her to go, and you're aware of that situation.
Yes.
But she's been here today. She seems to be doing better since she's on the Zyprexa. She does come to, she's been in contact with me
All right, so when
since
is
she
the,
got out.
since she's been released, has she contacted Mr. Williams?
On Friday, just Friday, 6 days ago, according to her. She couldn't remember quite what it was, but her brother said you didn't have the phone long enough to talk to him before that. But he's saying it's been since Friday, but I can have him brought up as well.
Yeah, let's have him brought up.
Hernandez?
State, are you, based upon so far what you've heard from Mr. Piker, are you seeking to, you want a bond increase?
No.
No.
Just based off of what I've been hearing, it seems pretty straightforward that she is now kind of getting back on track.
Okay. All right. So what is your name, sir?
Julio Hernandez.
All right. And we're not on the record. I'm just trying to gather out information. So what is the relationship to Mr.?
I'm sorry.
Yeah. What's your relationship to her?
I'm her older brother.
All right. So is she staying with you now?
Yes.
All right. And
About
are you
2 weeks.
helping? That's okay. No, I appreciate it. Are you helping her with medications to make sure she has those?
Yes, I keep on telling her, who's your doctor? I need to know what your medicine is. When you run out, so we can go pick it up. So I've been kind of keeping on her with that.
And you know who her pretrial officer is?
No.
All right. So,
I think you do. That was the man she met last Friday. You know?
Yes, she's been talking to him, but I've not met him yet. I don't know who he is.
all right. So counsel, what probably needs to happen, and of course, this is her case, not yours, but I'm trying to make sure that everything stays on track with her mental health, and I know the state is as well. Counsel, you probably need to give him the phone number and information for Freddie Williams, so that if something were to happen, she's not on her medication or she's missing, then you can call Mr. Williams and say, this is what's going on, and let the court know. Because I can tell you, neither the state's position or my position is to have her locked up and not receive the treatment that she needs. Before, the state has just informed the court, at first they were looking at a bond increase, but now, since we know everything is back on track and the issue is with her mental health, and it wasn't just her just blowing off things. So what I'll do is I'm going to continue on bond with the same conditions. They'll continue. She has a no contact order with Lonnie Rodriguez and no possession of firearms. So those are her conditions. And defense counsel will give you do you need a sheet of paper or anything for the information for Freddie Williams for him?
No, I have it, and she has it in her phone now as well. I saw it.
All right, so defense counsel will give you information, and I'm sure you have his information as well. If there's an issue, you let the court know. As I said, we're trying to make sure that she stays on her medication so that she's not in custody necessarily while she's waiting for this case to be resolved.
Okay.
All right. Thank you so much for coming down, and thank you for your help.
Thank you.
All right, and so this other matter, because she is on bond for an injury case.
Yes.
So has anyone sought out mental health court to see if that's a consideration potentially for her?
I haven't.
Talked about it just yet, Judge.
All right, so if y'all will see about that, because otherwise, if you wait till perhaps she's indicted, then the ball is rolled into another direction, and who knows, the state may end up saying she would be a good candidate for mental health court, but then there's a lot of extra loops to jump through for that.
And possibly when I talk to Lisa, I'll get more information on Dr. Yolanda to see how long she's been treating, because maybe her input into this may lead us to understand more what allegedly happened on the incident date. And we can consider that too.
All right. Is there anything you need to address with me?
No, that's good. Thank
All
you.
right, just make sure you stay in contact with everyone. That's the
I will.
issue. When you're not in contact,
Yeah,
that's when people start to worry what's
Yeah.
going on.
they'll start keeping contact with us.
All right.
Since she's been out, she has.
Yeah.
Yes. All right. Thank you. Keep up the good work, okay?
All right.
Thank you.
Thank you.
Thank you.
Thanks.
Okay. All right. Could I see the parties with the interpreter, please? Yes. It is,
Ruben Torres Levi.
yes, Ruben Ovalle. And Norma, on this, if you'll write the date that they're supposed to be coming back, that way pretrial services will know. All right, so on this case, the court is in receipt of the agreed protective order
Thank you, Judge.
and court signing it.
We'll have our staff copy that over for the defense.
Okay. All right. Counsel.
Thank you, Judge.
All right, so are there immigration issues? Mr. Ovalle, are you a citizen?
No.
All right, are you all going to take care of the immigration issue?
We in the process of that, Your Honor.
Okay.
And just for the record, Judge, we are, or for your information, we received an offer today, and then we want to have that discussion so that we can take the proper measures with what the immigration implications will be.
And do you have all the discovery other than the protective order
We,
items?
we're close to that, Your Honor. We had a discussion today where I was looking for some information and we're discussing whether or not it exists. So I don't want to say it hasn't been turned over. There's an indication that some pictures were taken, and the state does not have them. And so they're gonna look into that.
All right, so it's just photos, correct?
There's also an indication that there's audio that was recorded. The state has told me they've turned it all over. I've looked through what I have and it's unclear to me whether it's all been turned over. So I'm gonna go back through that. The issue with that for me, Judge, and why I can't do it in this moment is it's in Spanish. And so I just need to sit down and confirm.
Okay. I'm sorry, just one moment. Mr. Piker. Okay, Freddie Williams said he's only talked to her in April.
She gave me his name and phone number.
All right, so let me just have her wait just one moment.
Okay.
Norma, could you have Freddie Williams zoom in, please? All right, sorry about that.
Thank you.
So there's photos, audio, anything else?
But then once we review the CPS, there could be things that come from that.
Okay. And you all have the CPS records in your possession?
Yeah, we're gonna have them we're gonna make the copy and we'll give it over. All of our staff help us out with that.
All right, Ms. Ferguson, on this, can you give me a 30-day reset? This will be the final reset for discovery.
Okay, thank you, Judge.
Sure. All right, we'll come back on July 8th.
Thank you, Judge.
You're welcome. Do you have any questions?
No. No.
All right, thank you.
Once we sign the reset, may we be excused, Your Honor?
Yes.
Thank you, Judge.
When we get Freddie on the phone,
Yes.
it's possible that she got a hold of her old probation officer who gave her the stuff.
Okay. All right, we'll find out. I just don't want any confusion.
Because I think I remember her saying something about that too.
Okay,
So either way,
okay. And she's still here, correct?
in the hall.
Okay, thank you.
Excuse your honor.
Yes, thank you so much.
For the lifetime recovery.
All right, Freddie's on Officer Williams.
These are gonna go through, but that's what they call them.
Yes.
Where he got the information.
Okay.
And then here's, they also use his brother's phone.
Hello? Can you hear me?
Hi. Yes, hi, Mr. Williams. So,
Hello.
could you come down, please? All right,
You
so
said what, ma'am?
Officer Williams, hi.
Oh, I'm sorry.
So they just showed me a message where they were, I believe she was in touch with her previous officer, and the previous officer gave your number. So
Mhm.
when would you like to see her?
She can report, honestly, I guess tomorrow, because I'm here in office.
All right.
Yes,
Sir,
yes.
all right. So she's gonna report there tomorrow. What time do you want her to report?
It doesn't matter, anytime between 9 and 2 is fine.
All right, so you need to report between 9 and you say 9 and 2?
Yes, ma'am.
All right, so find out from her brother if he can have her there no later than 10.
Between 9 and 10 tomorrow probation?
Yes.
Yes.
All right, so they'll be there at 10.
Okay.
All right, and do you know the location?
I'll tell them.
Yeah.
It's where probation is, right? On Comel.
All right, it's on Kamau.
Yes,
All right.
222.
All right, so Mr. Williams, if they're not there by 10, just let the court know.
Okay, yes, ma'am.
All right, thank you so much, and thank you for zooming in right away. I really appreciate it.
Oh, yeah, no problem, ma'am.
All right, thank you. Thank you.
Bye.
All right, thank you.
You're welcome. Anyone else who's ready? Because we are breaking at noon.
Leave I am,
All right. All right, the court is calling Xavier Doxey. Okay. Yes. So she's coming back on the 30th? On the 30th. Okay, we're right here. July 30th. All right, thank you. Are y'all ready to proceed?
Yes, Your Honor. Yes, Judge.
Court is calling 2019 CR 9540, State of Texas versus Xavier Dante Doxy. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
Ramirez for Mr. Doxy, Your Honor.
Are you Mr. Doxy?
Yes, ma'am, I am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxy who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson with intent to damage a habitation or place of worship on December 13th, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 5 on or about the 12th day of March 2024 in Barry County, Texas. The defendant Xavier Dante Doxy, defendant there failed to conduct himself in a proper and orderly manner when reporting to the supervision officer at the Barry County Community Supervision and Corrections Department in violation of condition number 5.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor. That is correct.
All right, is that the agreement?
That is, Your Honor. We would ask Your Honor for the honor to consider lifetime recovery. If that's possible.
All right, so in the motion to violation of condition number 5, what does that mean? How did he fail to conduct himself in an appropriate manner?
My understanding, Judge, is that in the justification, it states that he reported to be under the influence of methamphetamines during an office visit.
All right. So has he been to safety before?
No, Your Honor.
All right, will he be accepted into safety?
He does have a history of drug use, Your Honor, marijuana and amphetamines. He did complete state ISS in December of 2021 or March of 2022. And he did complete SATA June of 2023 to October of 2023.
And I'm assuming felony drug court would not accept him because previously I ordered felony drug court.
He was not referred due to being in the SATA aftercare program, is what it says.
All right. I'm going to give you a choice. Sometimes I can give people choices, sometimes I cannot. I do believe that you have a drug problem because everything that I see is related to your drug issues. I can sentence you to 6 years in the prison, or what I can do is I'll refer you to felony drug court. Maybe felony drug court will accept you because you're not in any other program, or either you're going to safety.
I'll take safety.
All right, so I'm going to deny the motion, alternate amend conditions. To include, the first thing I want is a referral to felony drug court. And then the second, if felony drug court doesn't accept him, then it'll be safety. And there's going to be the UA hotline upon release and 120 sober meetings in 120 days. Why are you not able to stop using? What's going on? Do you have a support system? Do you not have a support system?
I have a support system now that was not implemented at first.
And who is your support system?
It's just a church family.
All right, your go-to should not always be to use drugs. I understand that sometimes they always say change people, places, and things, but when there's an issue, your automatic response should not be use drugs. If you're having an issue, your automatic response should be, okay, I think I'm going to go on the path of losing drugs. Let me call my sponsor. Let me call probation. In this court, if you're thinking about using drugs, you know you're not supposed to use drugs. All you have to do is call probation, and if they're not responding, all you have to do is come into court, and you can come into court and say, Judge, I'm on probation out of your court. I'm struggling right now. I'm thinking about using drugs. And guess what? You'll receive help. But if you're just walking into probation, high on drugs, that's not a good look. Do you understand?
Yes, ma'am.
All right. Is there anything else that you need from the court to be successful?
Paper of, from you to, recruiter.
I'm sorry?
Think about trying to join the military, so like.
Oh, well, I don't want to step on anyone's dreams, but they may not accept you.
I understand that.
All right. But if you let probation know that's what you want to do, I'm sure they'll have a contact number. And I think if you Google, there's a 1-800 number you can call and you can see if they'll accept you. And because of the fact that it's felony drug court, I'm going to extend him for 2 years. All right. Anything else?
Okay.
But we're off the record. But yes, please do look into the military. Who knows? They may accept you. There was someone who spoke at the felony drug court graduation. He said that everybody told him, you can't be an attorney. You can't do this because of your history. Guess what? He graduated, and 4 years later, he's an attorney. All right. All right. Good luck to you.
Thank you. Thank you, Your Honor.
You're welcome. Yes, he's to remain in custody. Carl Fuller. Yes. Why is he not in the courtroom?
With his family waiting for my response with the ADA. The ADA is asking for a 30-day reset.
Oh, no, he needs to be in the courtroom.
I'll go get him, Your Honor.
All right, sure.
Here we broke.
Yes. All right. You're on this side, counsel. All right, who's the prosecutor on Carl Fuller? You can unfold your arms. Thank you. All right, where are we on this case?
Judge, I think this is the first setting. I just wanted time to reach out to the parents, a few parents that I think that are involved. There's a school principal, and I wanted to see if we could reach out.
All right, Ms. Ferguson, on Fuller, if I can have a 30-day reset. And do you have all the discovery?
I believe so, Your Honor.
All right, we're going to come back on July 11th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. Bradley Galbon.
Judge.
Hello.
And just for the record, Judge, his name is actually Galan.
Galan?
They indicted him on one case correctly, the other case they put him Galvan.
Now, on both cases, they have him as Galbon.
Indictments, they should be correct.
One indictment has Galan, one has Galvan.
Okay.
All right.
So we asked for an immediate approval.
Let me see. All right. So, Mr. Bradley T. Galan, why were you late for court?
I just didn't make it here on time.
All right, so I require everybody to be here at 9. That's when docket starts.
Yes, ma'am.
So you know where the court is now. You shouldn't be late again. You understand?
Yes, ma'am.
All right, so where are we on discovery?
Judge, brought to my attention, I believe it was something that was maybe slipped through the cracks last time, but today I went over many of the warrants and affidavits that we need to request, or I have requested. I sent an email off, and in fact, before you approached, I asked, let me get this email out. And I believe that I have everything requested. Just requesting time for that. It's several different things. There's a Google and there's a Google geofence that that Texas Parks and Wildlife Department uses. So it's a little bit more than the average case.
Oh, well, I always tell people think as a judge, you should know everything. So I'm looking at the charge, the taking of certain wildlife. Yes, so I'm gonna have to look up and see what level felony this is.
That's I believe a third degree.
All right, so I'll see, I like when we say believe, so so I'm gonna have to look that up myself. All right, so it's gonna take some time to.
Well, what I'm saying is at least 30
State
days
jail
for
action.
discovery purposes. I mean,
Mhm.
I've dealt with Texas Wildlife Parks, whatever you call them, and they're really good about documenting everything, so I'm assuming that's what's the case. And I should be able to get it since they'll probably be in contact with me pretty shortly after this.
All right,
I think
so-
giving myself,
So how much time are you all asking?
I'm asking for at least 30 days, if not 45 days.
Okay.
I have no objections to that, Judge.
All right, so Ms. Ferguson, can you give this a 45-day reset?
I can do the 22nd or 23rd.
July, correct?
Yeah, I'm gonna look that up, so I'll know.
23rd.
So we're to recall for July 23rd for discovery.
Yep.
All right, is there anything else?
No, Judge.
All right, and I'm gonna look that up to see, so we can turn I believe to, we know.
We know.
All right, so both will be set on that date. And I'm assuming there's the labs are in, since the drug case was indicted. All right. Is there anything else? All right, once you sign the reset form, you're excused. Right. Moses Ross, come forward. Come forward. Good morning. All right, we're going to recall you for June 10th.
Okay, yes, ma'am.
All right, once you sign the reset form, you're excused.
Yes, ma'am.
All right, thank you.
Thank you. I'll see you June 10th.
All right.
We'll take it to you.
Court is calling night mag number 754466, state of Texas versus Robert Flores for the state.
Zach Dunn for the state.
All right, the attorney on this is Marissa Giovinco. Marissa Giovinco contacted the court and said that she has had no contact with the client. This is the second violation report. Pretrial services said that they have attempted to make contact with the defendant. The court gave the defendant 15 days to comply, and pretrial services said they still have no contact with him. Deputy Laura, did you make an announcement?
Yes, Your Honor, there's someone in the hallway.
State?
Your Honor, the state will respectfully request a bond forfeiture.
All right, the court will issue a judge's warrant and remand the defendant without bond. If he makes an appearance, the court will reconsider.
Thank you, Judge.
Thank you.
Doesn't forgive me for the now without one, correct?
Yes. You're welcome. Andrew Guerrero. All right. Hello. Hi. Thank you.
Judge, this is a compliance hearing.
Okay, let me just review this. All right. Hello. All right. They say that you're doing just okay. And you understand why the reason is just okay and not fully doing well.
Yes, I think it's because I had came out dirty on the UA.
Yeah. So sometimes people forget certain things. they are sort of far removed from when they were granted probation. You were granted probation on November 19th, 2021. And at that time, I'm sure if it was your first offense, you were thinking, oh my gosh, I could be going to prison for 10 years, right? And so once people are on probation, they forget the trepidation they had about potentially going to prison, and they get a little lax. You're not allowed to use marijuana on probation. Here's the thing, that's technically not my rules. That's the legislature's rules. If you want to write your legislator and see if they'll pass a law to allow people who are on probation to use marijuana and to drink alcohol, you can do that.
Yes, ma'am.
More likely than not, they're going to say, no, we're not doing that. So when you're on probation, you're on probation. You can't use marijuana. You can't be trying to use the system and say, oh, well, I'm doing CBD.
Yes, ma'am.
Because I see the CBD places throughout San Antonio. You're not allowed to do that. Do you understand?
Yes, ma'am.
They want to patch you. I don't know how the patch will do with as far as the marijuana levels. I'm thinking more along the lines, you're going to do the UA hotline, and they're going to be testing you for levels, and those levels had better be going down, and they better get to negative. Do you understand?
Yes, ma'am.
Is there anything you don't understand from Port?
No, ma'am. I've been doing everything that I have to do. Is just just a little bump in the road.
All right.
Yes,
That bump in the road
It
could
could.
cost you 10 years.
Yes, ma'am.
And whenever you get ready to do something that you think maybe you won't get caught, or I don't know if I should do this or not, you need to ask yourself, is it worth potentially 10 years of your life locked up? Okay.
Yes, ma'am.
All right. So what I'll do then, I'm going to alternate in his conditions to the UA hotline.
I was just gonna ask a question. I was gonna say, because I know you hear it all the time, but people are out there, it's because CBD right now is the thing. Because people can't smoke weed, so CBD is the thing out there right now. But I was gonna say, if anything, I could take classes, or I'm doing everything I'm supposed to do.
Oh, we're gonna hook you up with the UA hotline. And here's the thing about the UA hotline, which I love. The UA hotline is random, but you have to call in every day. And they may tell you,
I have to call?
Yes.
Okay.
They will either tell you come in and do a UA. You never know when they're going to tell you to come in and do a UA. You understand?
Yes, ma'am.
All right. So, Ms. Abrams, we're going to do the UA hotline until further notice, and test him at least twice a week to see if the levels are coming down. Once the levels are 0, we'll just do the regular UA hotline. Sometimes he'll call, he'll be tested. Sometimes he won't. We'll see what happens. Is there anything else he needs?
No, Judge.
All right. Don't be that person who's right at the door about to have completed probation, and then you want to do.
I was going through some things, but everything's back in order and in line, and I'm doing
Well,
what I have to do.
Here's the thing, when you're going through things, your go-to shouldn't be something that could potentially result.
Medication, ma'am. So, and I don't want to be hooked on, they want to give me like Xanax and stuff
No,
like that.
here's
I
the
don't wanna
thing.
take those things.
I want you to hear me clearly.
Yeah.
Oh, okay.
When things are going haywire in your life, your go-to should not be to do things that could potentially result in you going to prison for 10 years. You understand?
Yes, ma'am.
So we're having this conversation, but the next time we have this conversation, you know where it's going to be? Either you're going to have made bond, or either you're going to be brought over from the jail, and it's going to be in the form of a motion to revoke. All right? All right. Good luck.
Thank you.
Sure. Just have a seat. They'll go over new conditions with you. All right. Joshua Alcaraz. Joshua Alcaraz. All right. Could I see a prosecutor? And this is a PR bond. Court is calling NIBAG number 764003, State of Texas versus Joshua Alcaraz for the state.
It's act on for the state.
All right, this is a violation report. This is the second violation report. The defendant has not reported to pretrial services. The court allowed the defendant a chance to report, and the court gave the defendant 7 days to obtained compliance. He has not. According to the report, pretrial services officers have reached out to all of the collateral contact information that was provided. Deputy Laura, did you make an announcement?
Yes, Your Honor, he is not in the hallway.
State?
State would respectfully request a bond forfeiture, Your Honor.
All right, the court will grant a judge's warrant, remand the defendant without bond. If he makes an appearance, the court will reconsider.
Thank you, Judge.
You're welcome. Marvin Ortiz. Hello, you're on this side, counsel. It's been requested by security for security reasons. All right.
In all courts, left side.
Oh, no, this is our court. I followed through with security. It's what security says is best for them. I believe that everybody should stay in their own lane. I tell everybody, I'm not security, so I'm not going to be in charge of security. All right, where are we on this case?
We need a Padilla letter.
Okay.
For to be able to enter the place.
All right, and does he speak English?
Yes, he does.
Okay. You need an interpreter?
Yeah, it's almost better.
What? Okay. I just asked him.
Yeah,
He spoke English.
let's speak, please speak English too.
All right, so here's my question. Throughout these proceedings, are you going to need an interpreter?
Yes.
All right, so for now, he can speak in English, but if he wants an interpreter, I'm going to just make sure that interpreter is always here for him.
In the future,
Yes,
not for today.
no.
Okay.
Oh, because he really doesn't need an interpreter,
Right.
but since he wants to say he needs an interpreter in English to me, we're going to make sure that he has one.
Just for the plea, right?
No, each time he comes to court, we're going to make sure an interpreter is here for him because he's saying that he needs an interpreter, correct?
I'm
Oh.
not sure on your honor. Actually, I'm not sure.
And that's probably nowhere on this question.
Yeah, yeah.
All right. And so with regards to the,
La verdad, sí entiendo inglés, sí hablo inglés, pero no sé hablarlo muy bien.
He
Yeah,
says he
he
understands,
understands
but
it
he
real
doesn't speak it.
okay. All right. So are you retained? Are you going to see about the immigration issues? All right. Norma,
Judge, yeah, I'm gonna have issues with Odyssey.
Yeah.
I had all the attorneys as hires, so. I don't.
Yeah, I know.
I'm gonna fix that.
I look at him going, I look on my QuickBooks, I go, that's what it's for money.
Lance is
Yeah.
requesting on all.
all right. So he needs an immigration attorney.
Him feedback.
I have the number.
He has.
Okay. All right. And then did you give them all discovery?
Yes, Judge.
Yeah, I have.
And our state has given it.
Okay. All right, Norma, reset this for 45 days, and that will be your plea deadline date. If your attorney wants to come over sooner, because maybe he has the Padilla letter, you can always ask the court to put him on the docket sooner.
Okay.
All right, we'll be back on July 22nd.
Ah, pero podemos venir antes, ya que tenga la cárcel para ir. July 22nd.
Yes.
Ya, sí, esperemos que se entienda. Sí, sí entiendo bien.
All right, who's here on Fidel Escamilla? Court is calling 2024 CR 5540, State of Texas versus Fidel Escamilla. Can I have parties announced for the record for the state? Defense?
Sharon Thorne for the defendant.
And are you Mr. Escamilla?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
All right. Mr. Escamilla, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the document entitled Court Admonishment with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Escamilla, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
That was a slow answer. Are you a U.S. citizen? All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yeah.
According to the plea, 10 months in the state jail facility and there are no applications. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence? All
State office.
No objection, Your Honor.
right, state, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. First of all, in checking with your clerks, he has 120 days credit. We ask that you give him credit for any and all time that he spent on this. We ask that you follow this plea bargain. I do believe it's in his best interest. We discussed all different options, but at this point, we do believe this is the best interest. So we ask that you follow the plea bargain as stated and grant him his credit for the time.
All right, thank you. Excuse me, sir, in the check shirt, you need to have a seat. All right, the court, as previously stated, is finding there's sufficient evidence to find you guilty. Court is going to find you guilty, sentence you to 10 months in the state jail facility, give you credit for any time served. I'm going to request the therapeutic community. It doesn't increase the time that you're in custody. So for example, 10 months passes, you're done, but they say, he needs more time for his drug treatment. They're not going to keep you because you're in the therapeutic community. It's probably a good placement to you to help you with your drug issues. All right, anything else with regards to sentencing?
No, Your Honor.
Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Escamilla, how old are you?
43.
All right, here's the thing. These cases tend to pile up on people, and before you know it, you're habitual. And at some point in time, even if it's a state jail felony, if you're labeled a habitual, you could be looking at 20 years in the prison. Heroin use, any type of drug use with illegal substance, the people who are selling that, they don't care what goes in it. All they want is repeat customers. If somebody dies, there's always somebody else who's available to use. You understand?
Yes, ma'am. Just for the record, I really never, this is the first time I was using heroin, but like I said, I was on a supplement for a decade. You know, I started hearing voices and, when I was taking my brother to, his mental, health seminar, I think, I picked up a pamphlet and it said what to do when you hear voices, and it said challenge them and question them. And so I did, you know, so I've been on a pilgrimage for 10 years. And
could I have his file back, please?
You know, and like I said, it's the only without it. In short, is the only way to get granted an audience to be present here, and you know, admit that, you know, and I'm still on it. It's been actually over a decade last year, but because I had to quit the experiment early because of eternity, and you know.
All right, so I'm not a medical doctor.
No, I know.
But maybe you don't want to be the guinea pig or the
No,
experiment.
I meant, like I mentioned, I wanted to stop doing heroin, but because like I said, it cost me my parental rights for my daughters. Like I was a single dad for like when this incident happened, you know. But like I said, it was intense, academic understanding between me and the voices, who I assumed was the Central Intelligence Agency, you know.
And counsel, you believe he's currently competent?
I do, Your Honor. He does understand what he was charged with. He does understand what happened that day, and he does understand he had heroin. So in that respect, I do believe he's competent.
All right, so Mr. Escamilla, here's the thing. I'm going to ask them when they take you into custody to help you with mental health and to help you with drugs through the therapeutic community. When you're released, if you cannot find a place to go, you can always come back to this court and I will direct you to the Center for Healthcare Services and some help with your drug problems. You understand?
Yes.
All right.
That's basically what I've been trying to get.
All right. So you can always come back here. All right. Good luck to you.
All right. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, counsel. All right, David Perales. All right, so where are we on this case?
Your Honor, if I may explain briefly.
Yes.
For Mr. Perales, the only felony appointment letter I've gotten on him is for continuous family violence, which evidently was dismissed and reduced.
Mm-hmm.
And then I got the notice, evidently, because we found that out today, or we're trying to figure that out. But I got the notice today to be here for this hearing on the CTD side. We
Okay.
had it worked out, but we'd like a plea deadline date so we can talk through it and he can talk to his family, because I found out about these two cases today.
Okay.
And
Yes.
I'm sorry to interrupt. The other case is actually set for July 9th. I don't know when they dumped everything over, it's getting different tickets.
They did give us two dates. One was set for today and one for July 9th, Judge. You know, we're gonna try to get everything.
All right, so this is what I'll do. I'll put it on July 9th.
That's fine, Judge.
And if y'all want to come forward sooner, just let the coordinator know.
Good, Judge. Thank you very much.
All right, so what is this tattoo, no love? Do you have no love, or people are not giving you any love, or
I got this tattoo years ago, man.
when? How old were you?
I was like 18, 19. I'm 30
Do you
now.
do you still want to keep that?
No.
Okay.
No.
I'm always curious about tattoos because I'm wondering, one, do people regret having them? Do they still want to keep them? And sometimes I want to know what the meaning of it was. So what were you going on at that time in life? Were you?
I was locked up for the first time.
I'm sorry?
I was locked up for the first time. I was just going through some things, I guess, in my own mind. You know what I mean? I was gonna go to time, I thought, and I don't know. I just went wild, I guess.
Okay. All right. We'll see you back on July 9th. Okay.
Thank you, Your
All
Honor.
right. Thank you.
Excuse Your Honor.
Yes.
I'll do the video as soon as I can.
Everyone needs a lunch break. Rogelio Valero. Court is calling 2024 CR 1726, State of Texas versus Rogelio Valero. Can I have parties announced for the record? For the state,
Jason Garahan, Your Honor.
defense,
Robert Geary, Your Honor, for defendant Rogelio Valero Jr., and we're ready.
Are you Mr. Valero?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, we have, Judge.
Court will find that the state is in compliance with discovery. Mr. Valero, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? You need to speak up.
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Valero, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? All right, you're whispering.
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? All right, you're whispering.
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that he was. And
Miss-
is.
Mr. Valera, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's $1,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes,
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there have not. Judge.
Outside the plea, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, and the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State Exhibit number 1 with its attachments.
Defense is reviewed, Your Honor. We have no objections.
All right, states you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, we have. Judge.
Anything you wish to say on behalf of your client?
Judge, just in regards to my client's financial status at the moment, this cause arose out of a situation where he was being evicted from his longtime home. He had been terminated from his place of employment. Since then, he was dutifully been trying to find employment. He had been unsuccessful at the time, but is still on it and trying to get employed. We would like the court to take that into consideration when rendering the sentencing at this time. My client has the utmost competence that he can and will abide by all the provisions of deferred adjudication, Your Honor. It's just that any assistance in the matter of financials currently would be much appreciated. Thank
All
you.
right, thank you. How long have you been unemployed?
2 years,
All right, how do you support yourself?
side jobs.
All right, so you're gonna have to get employment, you
Yes,
understand?
I've been doing that now.
And I know it's hard,
Yes, but
but I see signs all the time for employment at McDonald's, and McDonald's actually has a great benefits plan.
been doing all of the above.
All right. Do you have any children?
No, ma'am.
All right. Are you staying with someone now?
Yes, ma'am.
Who?
A friend.
Who is this friend?
He's a longtime friend, childhood friend.
All right, so is he in the witness protection program or
Oh,
something?
no.
So what's his name?
Juan Martinez.
All right. So probation, he says he's living with someone by the name of Juan Martinez. All right, and if you drug
I've
test,
also applied for housing also.
okay. If you're drug tested today, what are the results gonna be?
Uh,
And here's the thing,
not
before
good.
you, not good? All right, positive for what?
Marijuana.
No, is,
Marijuana, ma'am.
and what else?
That should be.
No. Here's the thing, probation will UA you today.
Oh, yes.
So marijuana and what else?
Controlled substance, ma'am. The
And
last
what
one.
substance would that be? Yes, you have to tell me. What would it be?
Meth, ma'am.
Okay. That wasn't hard. Here's the
No,
thing,
it's just-
you've got to admit what
Yes,
your issues
yes,
are.
ma'am. Yes, ma'am.
There's no need to be embarrassed because guess what? Everybody in this courtroom is working on improving their life.
Yes.
Nobody in here is perfect.
Yes, ma'am.
So where you are now, hopefully, after you've completed this probation successfully,
Yes, ma'am.
you will not be back here.
Correct.
5 years deferred adjudication, $1,000 fine probated, regular reporting by Zoom or in person, proof of employment within 30 days, no employment as a home healthcare provider or with minors. I'm going to do a referral to felony drug court. You need to be honest with them. And the way you were being wishy-washy with me, you cannot be wishy-washy with them. You need to let them know what your issues are. That is a good program if you work the program
Yes, ma'am.
honestly. They will help you with housing. They will help you with your drug issues. You understand?
Yes, ma'am.
And if the person you're staying with has a drug issue, you all should not be living together.
That's, yes.
I'm going to want field visits 1 time per month until in treatment. If he's not accepted in felony drug court, I'm going to want a TAP evaluation and follow TAP recommendations. I'm going to want the UA hotline until further notice. 120 sober meetings and 120 days. We'll hold off on the DOEP course until we figure out what the TAP evaluation said or probation says. There's going to be 120 hours of community service restitution. I'm going to require you to do a work program. Once you complete the work program, the court will deem the community service hours satisfied. Probation, is there anything else he needs?
Just to confirm, you said 120 community service hours?
No, 100 community service hours.
Nothing else.
Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand? We can go off the record. Here's the thing. In order to be successful, you need to be honest with the court. Oh, and you're on lunch break. You need to be honest with the court.
Yes, ma'am.
If there's an issue, if you feel as though you're going to use, guess what? Talk to your probation officer. That's the only way you're going to be successful. talk to them and say, I think I'm gonna use. Or even if you do use, tell them, maybe I've used. Guess what? They're gonna try to get you treatment. If you feel there's an issue and they're not addressing it, you can always come back to the court. I'm here mostly every day except for weekends. All right, so remain in the courtroom, probation will go over conditions with you. And everyone else, we're on lunch break.
Judge,
Yes,
was it 4 or 5 years?
5.
5, okay. I didn't hear. I don't hear so good.